So yeah, thank you again, Patty. Good morning, everybody. Thank you so much for joining us today. As Patty mentions, my name is Rachel Bottomley. I'm CME's Project Officer for Workplace, and I also oversee the CME in Work programme. So I'm the main point of contact for employers engaged in the programme, as well as supporting with the work that we do around workplaces more widely. So I'm just going to spend the next 10 minutes or so just sort of setting the theme about why this is really important topic for CME and why we wanted to bring this to a masterclass. So workplaces have been a core part of CME's work for over a decade now, and that's because we know that this is one of the settings where people experiencing mental health problems are also experiencing high levels of stigma and discrimination. And we know that experiencing mental health stigma and discrimination at work is having a greater impact on people's lives outside of work. People experiencing stigma and discrimination at work are less likely to apply for promotion opportunities, less likely to speak up and ask for help when they need it, more likely to leave work before they are ready, and more likely to hold themselves back from future employment opportunities as a result of the anticipation that they will be treated the same way again. We are seeing attitudes shifting when it comes to mental health. Many organisations understand the impacts of poor mental health in the workplace and that there is a really strong business case for getting it right. But creating the culture change that is needed to eradicate mental health stigma in workplaces is not an overnight task, and it can be challenging to know where to start. So line managers, why line managers are so important, and this topic is so important. Line managers are quite often gatekeepers for mental health support in the workplace. They're usually the first point of contact for most of us when we need to speak to somebody about something, and how supported an employee feels can often be dependent on that individual relationship. Any employee who discloses that they're struggling to a line manager with a good understanding of what support is available and what procedures need to be followed will likely have a much better experience than disclosing to a line manager who does not. And as we'll see later on, having a negative experience like this at work can then lead to a reluctance to seek further help in the future. It can lead to employees feeling unsupported, needing to take time off, and even leaving the business. And this is a quote from our Smith study that we published last year. So this is an actual experience of somebody, just highlighting the difference, the huge difference it can make when you do have a line manager that is supportive and that understands. So we'll have a little look at what we actually mean at CME when we talk about informed and supportive line management. So firstly, when we talk about line managers, this could be any employee whose role involves having direct reports. So the job title might not always have the word manager in it. It can also include supervisors, team leaders, coordinators, foremen, superintendents, etc. And whatever the job title is, if that employee has responsibility for the oversight of other colleagues, that makes them a line manager. So a well-informed line manager, we would say, is somebody who has a good knowledge of their own organisation's strategic goals and internal policies and procedures. They understand that they play a really key role in upholding the organisation's legal obligations as an employer, and that they have a legal duty of care for their direct reports under the Equality Act 2010 and also under the Health and Safety Act, at Work Act 1974, etc. And they also understand that a big part of their role involves managing team dynamics, which requires a different set of skills, as well as leading by example. A supportive line manager is one who is able to open conversations about mental health with colleagues. They're able to listen to concerns or disclosures of illness or conditions without judgment and provide a compassionate response. They are confident in explaining what their role is in relation to discussing support and work with their colleague to identify and review reasonable adjustments needed to help that colleague stay in work. And they also role model anti-stigma and discrimination attitudes and behaviours that contribute to a mental health inclusive culture. Line managers also have a duty to themselves to look after their own mental health at work. And leading by example can also mean more than just talking about mental health, but taking action to prioritise their own as well as their colleagues' well-being. Line managers and supervisors who talk openly about mental health, sharing their own stories, if it's safe and possible, encourage and empower other people to open up as well. It creates a trusting and supportive two-way feedback environment where people feel like it's safe to talk about mental health, and so they do. And when organisation ensures that its line managers have got the knowledge and the skills and the empathy required to support the mental health needs of the workforce, it creates a more positive team environment. Employees who see their organisation via behaviours of line managers taking action to prioritise workplace wellbeing will be more engaged, they'll be more likely to take part in wellbeing initiatives. More employees seeking help early will reduce long-term absence rates, and that in turn relieves workload pressures on other colleagues. It's very well documented that employees with good mental well-being are more likely to be creative, to be loyal to the company, and to be productive. And recent data from the Deloitte Global Survey highlights that there is a global trend when it comes to recruitment now, with more than 80% of respondents saying that they consider an employer's mental health support or policies before considering accepting a job within that company. So I've made quite a strong case here for making sure that line managers have got access to the knowledge, skills and support that they need. But a surprising amount of organisations are still lacking in that knowledge, that health and safety in the workplace is no longer just about slips and trips and physical harm, but it also extends to psychological harm that can result from extended exposure to work-related pressure and stress. And also that failure to make reasonable adjustments for employees with mental health conditions is a specific form of unlawful discrimination that's outlined in the Equality Act 2010. Lots of organisations now have got mandatory induction training available for new starters that does introduce these topics, but very often people can get promoted to managerial roles internally, and that might be because their technical or business skills of the actual jobs or tasks itself. It may have been some time since that initial training, and it might not have been knowledge that the employee was required to call on a regular basis up until being promoted into that managerial role. So when the recruitment and induction process for managerial positions, as well as learning and development available once managers are in post, doesn't really explicitly outline the expectations and legal duties of the role in relation to employee mental health, that really important knowledge can sometimes be missing. And potentially that leads, in worst case scenarios, to the unlawful discrimination of employees experiencing mental health conditions. So I've just summarised here a few examples of some of the most common mistakes that we can see made by people in line management positions. Usually it is a result of that lack of knowledge and understanding. So some of those examples are refusing a request for a reasonable adjustment, either because they think it's not fair on the rest of the team, or because perhaps they think that workplace adjustments are only for employees with physical disabilities. Withholding work-related opportunities, and that can usually be in the example of promotions or not letting somebody take on new work or projects because there's been an assumption made that that employee wouldn't be able to cope. Avoiding or ignoring the employee, and that might be because that manager doesn't feel comfortable having conversations about mental health, and so they'd rather just avoid it, or because they're worried that they'll say the wrong thing, and perhaps do or say the wrong thing and make somebody feel worse. Moving them into another role without discussing it with them. First, breaching confidentiality by sharing details of the employee's situation with colleagues without their consent. Sometimes this is done with really good intentions, but other times it's just down to workplace gossip. Not allowing time off, and that could be to attend counselling or therapy sessions, which sometimes might be down to a misunderstanding that therapy also counts as a medical appointment. We've already touched on the business cost, is sort of higher absence rate, higher staff turnover, less engaged and productive workforce, and in some cases, in worst case scenarios, a potentially expensive and damaging employment tribunal. But there is also a much bigger cost that we're aware of at CME through our research. So on this slide, I've got some quotes, again, from the study that I mentioned earlier. We refer to it as SMIS, that's an acronym. It's the Scottish Mental Illness Stigma Study that we published last year. You can find it on our website if you're interested. I won't read all of these quotes out. I've been reading these out at various events for over a year, and I still find it difficult. But it's clear to see just how important this topic is, and just how important is the role that line managers play in creating and sustaining mentally healthy workplaces that are free from stigma and discrimination. And I think that you are all here today because you also understand how important that is. So as I mentioned earlier, CME have been working closely with employers and employees on this agenda for over a decade. We know how important this topic is, and we want to make sure that the knowledge about what works, what resources we've developed off the back of that knowledge are available to as many people in Scotland as possible, which is why we've launched this programme of webinars and online masterclasses that will be running until March 2024. So I'm delighted to say that I'll shortly be passing back to our colleagues Bill and Catherine from the Equality and Human Rights Commission for a much deeper dive into the topic of the Equality Act and reasonable adjustments. But before I hand back, I'd just like to quickly highlight some of the practical resources that are available on the CME website. So just to run through very quickly, we have got e-learning modules. They are open access. You do just need to set up a user account, but anybody can access that and complete them. They're divided up into chapters, so it's quite easy to dip in and out as and when you've got time. You can complete those as an individual, or we can work with you to roll that out as training options within your organisation. We've developed the Let's Chat tool, which is designed for line managers and supervisors and to support them in how to open up those conversations. And it gives some scenarios and examples and best practice ideas. We've got a series of guidance documents called the Spotlight On series, which touch on various different really important topics, including line managers and reasonable adjustments. And we've also got the CME in Work programme, which I mentioned earlier, which is available for all organisations headquartered in Scotland to take part in. So that brings me to the end. I have just popped my email address up there, but I will pop it in the chat later as well in case anybody's interested to know more. I will pass back to Patty now, but thank you very much for listening.
Thank you, Rachel. That was very informative and also quite hard-hitting, looking at the quotes there. I really encourage people to have a good read at the report. I've added the link to the stigma study survey in case you haven't seen it yet. So now we are going into as Rachel said, deep dive into how managers can make a difference, and also the duty of care and what that means in terms of looking after employees and putting in place reasonable adjustments. So without further ado, I'll just pass on to Bill and Catherine, if that's okay.
Thank you, Patty. Bear with us for just a moment, everyone, until we get our slides and notes sorted on our screens here. Okay, and I think everyone can see the introductory slide there. So firstly, thank you, Rachel, for setting the scene so well, setting out the critical role that line managers play in making reasonable adjustments in work for, to make reasonable adjustments work for both the employer, but in many ways, more importantly, for the employee. So before going into detail of today's session, I want to briefly introduce you to who we are. The Equality and Human Rights Commission is Britain's national equality body and has been awarded an A status as a national human rights institution by the United Nations. As a statutory non-departmental public body, it's quite a mouthful, established by the Equality Act in 2006, we operate independently of government. Our job, basically, is to help make Britain fairer by safeguarding and enforcing equality and human rights law, and we use our unique powers to challenge discrimination, to promote equality of opportunity, and to protect human rights. For instance, we can publish reports and guidance, we can review the effectiveness of the law, and we take legal enforcement action to clarify the law and to address any significant breaches of rights. Catherine and I, as mentioned by Rachel earlier, work in the compliance team in Scotland, and the purpose of our compliance work is to equip organisations with the knowledge and tools to better enable them to meet their obligations under equality and human rights law. In Scotland, all work promoting compliance with human rights law will be done with the consent of the Scottish Human Rights Commission, because we have a shared remit when it comes to human rights. Now on to the next slide, and in this session we're going to consider a couple of key questions. So firstly, how might any mental health issues of an employee feature under equality law? And secondly, what steps does equality law direct you to take as an employer to avoid unlawful discrimination? We'll give you an overview of the key provisions in equality law to support you to comply with your obligations and help create an inclusive workplace free from mental health discrimination, especially by providing what are known as reasonable adjustments. That will be a main focus of what we talk about this morning. This is not only about avoiding legal challenges and reputational damage, but as Rachel mentioned in her presentation, it's about supporting your staff to do their job effectively and getting staff with the right skills for the job. We have approximately 45 minutes for this session. We'll try and bring it to a close at around 10:30. If you do have any questions, then feel free to write them in the chat or raise your hand and we'll come to them when we can. We also have a Q&A slot after the break where there'll be further opportunity for discussion. I'll now pass over to my colleague Catherine, who'll take you through some of the key concepts and provisions of the Equality Act. Over to you, Catherine.
Thanks very much, Bill. Okay, so the legislation that we're looking at today is the Equality Act of 2010. And I'm going to introduce some key provisions in the Act which are relevant to mental health in the workplace. And then I'll pass back to Bill for some detail about one key provision in the Act on reasonable adjustments. So by way of a background to this piece of legislation, the Equality Act simplified and consolidated over 100 pieces of equality legislation and 40 years of case law. And that became the legal framework in place that seeks to address discrimination and also achieve greater equality. Now, the Act applies across Britain and it covers a variety of sectors. So it covers work, which we will be focusing on today, but also services and public functions, and housing, education, associations, and transport. And it also covers a huge array of organisations, from shops to the NHS, insurance providers, mortgage brokers, a real wide-ranging coverage. And it's going to be relevant to staff in a number of roles. So it'll be relevant to line managers, as we're focusing on today, but also others like human resources practitioners. Now, under the Act, protection is based on certain characteristics that people have, and these are known as protected characteristics. Now, there are 9 of these protected characteristics in total, and every one of us has one or more of them. So I'm just going to pause briefly and say, can you raise your hand or paste in the chat any of the protected characteristics? And I'll ask Bill to keep an eye on the chat and see how many we manage to get. So there are 9. Does anyone want to have a go? Does anyone know a few of them?
We have gender.
Okay.
Hannah's, you know, the obvious one, disability.
Brilliant.
Patty has added sexual orientation.
Brilliant.
We have pregnancy and maternity from Lisa.
Great.
Hannah has come in with religion or belief. Andrea has race. I'm losing count here. I think we're at, what's that, 6?
We're doing well. Okay. Okay, we're doing pretty well there. So let's just check what we've got. So age, did we have age? I don't think age came up. That's one of the protected characteristics. Disability, which we got. Gender reassignment is one of them. Marriage and civil partnership is another. Pregnancy and maternity, which we got, which is great. Race, religion or belief, sex, and sexual orientation. So we did get quite a few of those there, and not bad at all. I even struggle sometimes when put on the spot to come up with all 9. But those are the 9 protected characteristics there, protected under the Act. One of those characteristics that we're focusing on today is disability, and that protected characteristic can cover mental health conditions. But what does disability mean under the Act? So under the Act, a person is disabled if, firstly, they have a physical or mental impairment, and secondly, that the impairment has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. So I'll just tease out a bit more. Now, what do we mean when we say physical or mental impairment? Firstly, it's important to note that it does include both aspects, physical or mental. And it's usually determined by considering the effect that it has on a person. Okay. Now, in the context of mental health, it might include conditions with symptoms like anxiety and panic attacks. It might be certain disorders such as maybe an eating disorder, personality disorder, could be post-traumatic stress disorder, or mental illnesses like depression. Again, that's not an exhaustive list of examples, but those are just some illustrations of what might be covered under physical or mental impairment. Now, the second half of the definition, when we say a substantial effect, that just means more than minor or trivial. Okay, so more than minor or trivial. And that might involve it taking just much longer than it usually would to complete a daily task. And then for some impairments like depression or others, there might be cumulative effects, which when they're taken together, they become substantial. Okay, so it might be having difficulty getting up in the morning, but also household tasks taking longer. So it's important to consider that cumulative effect. When we talk about having a long-term effect, that simply means 12 months or more. Okay, and cumulative time should also be considered. Okay, so for instance, if someone has an anxiety disorder for a few months and then that develops into a period of depression, we should be considering that time cumulatively. And then finally, when we talk about normal day-to-day activities, that could include a whole host of work-related things like following certain working hours, following a set of instructions, using a computer, maybe driving, or even interacting with people. So just the normal day-to-day activities you'd expect someone to be able to carry out. Now, I hope that's given you a bit of an idea of the definition of disability, but I just want to emphasise that to avoid discrimination, it is sensible for employers not to attempt to make a really fine judgment as to whether a particular individual falls within this definition. Okay, and instead we'd advise just focusing on meeting the needs of the worker themselves or the job applicant. Now, Rachel did mention that with mental health, there can be a fear of stigma and a fear of discrimination at work. Now, in this context, it's really important to remember that a person's protective characteristics can intersect and result in particular experiences that might manifest in the workplace. So some people might experience perinatal mental illness, so that would cover both disability and pregnancy and maternity. And evidence also shows that LGBT plus people in Scotland are at a higher risk of experiencing mental health problems, while some people from ethnic minority groups note a certain stigma around mental illness in their communities. So it's really important to be alert to that range of experiences and how the different protected characteristics can intersect and affect the worker or job applicant's situation. Now, the Equality Act prohibits unlawful discrimination based on these characteristics that we've just seen. And there are a few different types of unlawful discrimination. So we have them on the slide there. So that might include a failure to make reasonable adjustments, could be direct or indirect discrimination. It could be discrimination arising from a disability, harassment, victimization, or a range of other protections like equal pay. Now, when I pass back to Bill, we're going to focus on the first one, which is the failure to make reasonable adjustments. But I'll maybe just give some brief examples to give a flavour of what the other terms cover. So let's take direct discrimination. That happens when someone treats you worse than another person in a similar situation because of disability. Okay, so that'd be the case if, for instance, during a job interview, the applicant tells the employer that they have depression, and then the employer decides not to appoint them, even though they're the best candidate. Okay, so that, as you can see, that scenario is tantamount to stigmatization and would be an example of direct discrimination. To take another of these examples, discrimination arising from a disability happens when a person is treated badly because of something connected to their disability. Okay, so it's not necessarily the disability itself, but something related to it, such as taking time off for medical appointments. So this kind of discrimination might occur, for example, when an employee with a mental illness is prevented from receiving a bonus because of time they've taken off to receive treatment, and they've been prevented from receiving that bonus without any objective justification. So that might amount to discrimination arising from a disability. Now, Bill will kindly share our guidance on the different types of disability discrimination in the chat. And I would encourage you to look at it if that would be helpful to you, just to understand some of these other types of discrimination. But just to finish up my section, when does protection apply under the Act? And it's a fairly straightforward answer. So protection under the Equality Act applies from the very start until the very end of the employment process. So you're protected from the moment you see the advert, when you're applying for a job, so the recruitment stage, when you're in the job, and even after leaving the job. Okay, so it is quite a wide-ranging protection. So, for example, when you're in a job during employment, there are a range of circumstances where the employer mustn't discriminate. So they mustn't discriminate in the terms of employment, which might include things like pay and hours, or in any opportunities for receiving a benefit. As Rachel mentioned this earlier, like maybe promotion or transfer or training. So the protection is quite wide-ranging there. But for now, I'm just going to pass back over to Bill, who will talk about one protection in particular, and that's reasonable adjustment. So Bill, over to you again.
Thank you, Catherine. You covered quite a lot there. Obviously, you know, the background to the Act itself. You covered the different protected characteristics, detailed different types of discrimination, and outlined when protections apply. But for the rest of the section, we're going to focus on one provision related to disability, and it's the most likely. It is most likely the key provision relevant to mental health and stigma at work, and that is the duty to make reasonable adjustments. If you have any pressing questions or require any clarifications, then please feel free to raise your hand or comment or chat, and Catherine will flag them to me. But on to the next slide, which is the first one on the actual duty to make reasonable adjustments. So this duty recognises that it's not people's impairment that puts them at a disadvantage, it's the things that we do as a society and the structures that we create that puts them at a disadvantage. There's a duty to make reasonable adjustments if something places a disabled person at a substantial disadvantage compared to someone who does not have that disability. The duty has 3 requirements, as you can see on the slide. These are to take reasonable steps to avoid any substantial disadvantage a practice, provision or criteria creates. Secondly, to take reasonable steps to avoid any substantial disadvantage a physical feature creates. Or lastly, if the disabled person is facing a substantial disadvantage because they don't have access to an auxiliary aid, to take reasonable steps to provide that aid. So to paraphrase, essentially, firstly, change the way things are done. Secondly, change a physical feature, or thirdly, provide extra aids or services. But let's unpick each requirement in just a little bit more detail. So that first requirement, substantial disadvantage created by a practice, provision or criteria, is about any formal or informal policies, any rules, any practices or arrangements, including one-off decisions and actions. You know, this could range from decisions about the application of HR policies, such as flexible working, to the allocation of car parking spaces. An example of this kind of reasonable adjustment could include allowing a disabled person to work flexible hours to enable them to have additional breaks to overcome any particularly severe symptoms of their mental health disability. The second requirement, that's the substantial disadvantage created by a physical feature, could cover fixtures, fittings, materials or any other physical element or quality of buildings, such as steps, entrances, emergency exits, toilet facilities, signs, etc. This will probably come up less frequently as it relates to mental health when compared to how often it will come up relating to a physical impairment. But for instance, the way an office is set out could possibly require an adjustment, allowing someone to work in a quieter space or to you know, make sure that their social anxiety isn't aggravated. The third and final requirement, that's the substantial disadvantage because of a lack of access to an auxiliary aid, is about a lack of something which provides support or assistance to a disabled person, such as text-to-speech software or the provision of a BSL interpreter or support worker. For mental health, for example, there may be peer support workers that could assist an individual if they experience difficulty in coping with new or uncertain situations, or perhaps someone could be provided with noise-cancelling headphones if they find that loud workspaces aggravate their mental health disability. So on to the next slide, which is the second one on the duty to make reasonable adjustments. And we want to consider when the duty is engaged. So the duty to make reasonable adjustments will not arise unless the employer knows or ought to reasonably know of the disabled person's disability, and that the disabled person is likely to be placed at a substantial disadvantage for reasons connected to their disability. Therefore, an employer will not be obliged to make reasonable adjustments to premises or interview processes on the off chance that a disabled person might apply for a job. But in a work context, the duty is not anticipatory. It arises only in respect of particular disabled individuals. Now, I should clarify that in the context of service provision, which can relate to work, if you're providing a service to the public, such as a shop or a bank, then the duty to make reasonable adjustments is anticipatory, but only insofar as it concerns service provision. As it relates to employment or work, the duty is not anticipatory. Employers will not avoid the duty to make reasonable adjustments where they did not know, but should have reasonably known about an individual's disability and substantial disadvantage. Therefore, any employer should take steps they can reasonably be expected to take and have systems in place to find out the relevant information about a person's disability. Now, there are circumstances when an employer can be assumed to know about a disability. Sometimes an employer's agent or employee knows of a worker or a worker's or potential applicant's disability, such as in their capacity as an occupational health advisor or an HR officer or recruitment agent. And in such a case, the employer will not usually be able to claim they didn't know about the disability. Employers therefore need to ensure that where information about disabled people may come through different channels, there's a way, suitably confidential and subject to the person's consent, to bring that information together to make it easier to fulfil their duties and make reasonable adjustments where appropriate. There may be particular challenges for an employer to find out about a person's disability related to a mental impairment. A stigma can often leave people reluctant to disclose, and that's understandable. So let's take some examples of what reasonable knowledge might look like with regard to mental health. So firstly, let's consider a scenario where a worker who deals with customers by phone at a call centre has depression, which sometimes causes her to cry at work. She has difficulty dealing with customer inquiries when the symptoms of her depression are severe. It's likely to be reasonable for the employer to discuss with the worker whether her crying and upsetness is connected to a disability and whether a reasonable adjustment could be made to her working arrangements. Let's consider a different scenario. Let's consider the scenario of a disabled man who has depression and has been at a particular workplace for 2 years. He's a good attendance record, good performance record, but in recent weeks, he's become emotional and upset at work for no apparent reason. He's also been repeatedly late for work and has made some mistakes. The sudden deterioration in the worker's timekeeping and performance and the change in his behaviour at work should probably have alerted the employer to the possibility that these were connected to disability. So employers should still consider issues of dignity and privacy and ensure that personal information is dealt with confidentially. For example, employers are permitted to ask pre-employment questions to establish whether reasonable adjustments to the recruitment process are required, but overzealous inquiries about health or disability might fall foul of the Equality Act's rules prohibiting pre-employment health questions. So the relevant part of the Act there is Section 60, and it sets out that it is an unlawful act and to ask health or disability related questions during the recruitment process until a job offer is made, except in very narrowly defined circumstances. So, you can ask an applicant if they need reasonable adjustments to a recruitment process, but this information should not be shared with the decision makers or the recruitment panel and should be used by the HR team to put the adjustments in place only. The Act does not prevent a disabled person from keeping a disability confidential from an employer, but keeping a disability confidential is likely to mean that unless the employer could reasonably be expected to know about it, the employer will not be under the duty to make reasonable adjustments. If a disabled person expects a reasonable adjustment, they'll normally need to provide the employer with sufficient information so that they can actually implement the adjustment. On to the next slide, which looks at the failure to make reasonable adjustments. So you might be wondering what counts as reasonable. This is a fact-sensitive question. The duty to make reasonable adjustments applies to all employers of all sizes, but the question of what is reasonable may vary according to the circumstances of the employer. What's reasonable in one circumstance may not be reasonable in another. Only a judge at an employment tribunal can make a formal ruling on the reasonableness of a given case. There's no objective justification defence available in respect of an employer's failure to make reasonable adjustments. The proposed adjustments are either reasonable or not, and there's no duty to take measures that would impose a disproportionate burden on the employer. It's also worth noting that adjustments must be made in a timely manner. So if there's an unreasonable delay, then that could constitute a failure to make the adjustment. On to the next slide, please, Catherine, which is the second part of failure to make reasonable adjustments. Just aware that we have approximately 10 minutes here. So in terms of a failure to make reasonable adjustments, further concerns. So to reiterate, reasonableness depends upon the circumstances. There's no one-size-fits-all cap. There may be a number of factors as shown in the slide here, but this is not an exhaustive list. You can see the factors there in front of you, and these are the types of considerations, the types of questions that you would take into account when determining whether something is reasonable or not. Now, in assessing what adjustments are reasonable, the focus must be on the practical result of the steps that the employer can take to remove the disadvantage, and deciding whether a particular adjustment would overcome any disadvantage might require the employer to consider a package of adjustments which complement each other to remove or reduce the employee's disadvantage. And since achieving the objective of one adjustment may depend on other adjustments being made to ensure that that original adjustment is effective. It's normally wise for an employer to consider obtaining an expert opinion on the likely efficacy of a proposed step. In cases involving medical conditions that are maybe less familiar or whose effects are less predictable, medical evidence may be advisable or indeed essential in some cases. This is likely to be the case where the impairment is a mental one, where it might be less obvious whether any given step would alleviate or remove the disadvantages experienced by the employee. Furthermore, the cost of the possible adjustments, together with the resources available to the employer, will be relevant as to whether the adjustment's reasonable. And you should note that you cannot charge for making reasonable adjustments. The employee should not bear the cost of any element of the reasonable adjustments. However, if an adjustment has a significant cost associated with it, it may still be cost effective in overall terms. So, for example, compared with the cost of recruiting and training a new member of staff, so it may be regarded as reasonable to have to make it, even if it is fairly pricey. But employers should not conclude that an adjustment needs to be cost effective to be reasonable. You have to take into account the employer's resources, the size of the employer. So often, the bar is set higher for public sector employers than it is for smaller private sector employers. And you might be expected to make adjustments that are not strictly cost effective because of this. Other factors include the extent of disruption that an adjustment may generate, planning permission requirements, health and safety considerations, etc. So, these are all factors that potentially are relevant to determining whether a specific adjustment is reasonable or not. If we now move on to, the next slide, which is potential reasonable adjustments. Now, in the breakout sessions, we'll think about different scenarios and discuss reasonable adjustments that could be considered with regard to mental health. But remember, there's no onus on a disabled person to suggest adjustments. The duty to consider making adjustments falls on the employer, but it is good practice for the employer to ask the disabled employee about possible adjustments, because ultimately, you know, it's the employee with the condition that knows the condition best and knows how to impact and manage the condition effectively. It's certainly advisable for an employer to agree any proposed adjustments with the employee before they're made, so they shouldn't really be imposed. An employer should ensure that a disabled employee's immediate line manager is fully aware of the adjustments made so that they can oversee them and make sure they're effective. In some cases, it will be appropriate for other managers in the organisation to be made aware of the adjustments in place as well, but not necessarily the details of all the disabilities that have you know, made the reasonable adjustments necessary. In some cases, a reasonable adjustment will not succeed without the cooperation of other workers. So colleagues as well as managers may have an important role to play in helping ensure that a reasonable adjustment is carried out in practice. Subject to considerations about confidentiality, of course, employers must ensure that that happens. So I think that's us just about there on time. We'll have time after the breakout to go into more details, but I was just wondering, Catherine, was there anything, you know, I think I've come in 5 minutes ahead of time there, so if there are any questions in the chat, then maybe we could you know, explore one or two of them there.
Okay, let's see. Sorry, I couldn't see the chat whilst I was sharing my screen. Let me see. So one question that's come in is, how does this work when a human resources person who may know about the adjustments required for the recruitment process are also on an interview panel? There's a specific question about recruitment and who can know about the reasonable adjustment request.
Yeah, I mean, good practice is to have a clear separation between, you know, the people who may be asking if any reasonable adjustments are required in the recruitment process, such as an HR professional, and the people who are actually sitting on the recruitment process. I think, you know, in that particular scenario, if there was an HR person who both knew about the adjustments necessary for the recruitment process but was also on the panel, then the employer is likely leaving themselves in quite a vulnerable situation there. So, you know, certainly my advice would be, you know, to find someone else, if at all possible, to take their place on the recruitment panel. Otherwise, there is a bit of a conflict of interest there potentially, and as I've said, you know, that would likely leave the employer in quite a vulnerable position.
We have another question in the chat. I'm not sure exactly when it relates to. It must have come in as we were talking earlier. Says, on that point, does that include issuing an absence improvement notice? Don't know if the person who's asked that question maybe wants to jump in and clarify which part they were referring to. Otherwise, we can come back to it at the end.
Yep, sorry, that was me. Hold on, put my phone down.
Thanks.
Hi, sorry. I think it was just, it was quite near the beginning. You know, if you're unaware of a person's mental health issue at the time that you are issuing an attendance improvement notice, where does that appear?
You cut off just towards the end there, Joanne, but I think the gist of your question was, you know, if you're issuing an absence improvement notice, but you don't know about a person's disability, is that the case?
Yeah, Yep, so the person has never highlighted to you that they have mental health issues until after you've issued the improvement notice. And now they're saying that they have mental health issues. So, like, where does it only came to light through the appeal process?
Yeah, so I mean, there's a degree of discretion available in a scenario like that, Joanne. And what I would say is that, yeah, you know, there's nothing wrong with an employer issuing an absence improvement notice, and if they don't know about you know, an individual's disability. However, if the individual then you know, appeals that decision and informs the employer at that stage that they have a disability, then, you know, the need to make a reasonable adjustment is then engaged, and an employer could consider you know, an adjustment to the policy itself, the absence management policy, and consider you know, potentially revoking the improvement notice in a situation like that, because you know, at the appeal stage they know about the disability, and therefore the duty to make reasonable adjustments is engaged. So there's nothing wrong with issuing an absence improvement notice if they genuinely don't know about a disability. But, you know, if the disability comes to light at the appeal stage, then an employer should consider whether a revision, an adjustment to the policy itself and how it's implemented is reasonable at that stage.
Okay, that's great. Thank you so much.
Yeah, just reiterate what Bill said in his presentation about when the duty's triggered, and what constitutes knowledge. So it's when you know or reasonably ought to know. So that's what we'd consider in that scenario as well.
Thank you.
Thanks, Joanne. And well, I think we're due a break now, so I'll hand back over to Patty and Rachel.
Thank you very much, Bill and Catherine. That was really good and really informative. And I always find very impressive how you can translate the Equality Act into something so clear and practical as well. So thank you very much for doing that. I noticed someone else added a question. So what I've been doing was taking the questions from the chat and putting in the Q&A. I'm conscious that some people might be joining through mobile phones and they might not have the function to do that on their mobile phones. So I'll keep doing that, but we'll pick up any other questions when we come back from the break, if that's okay. So now we're going to go into a 10-minute break. If people can come back for 10:41, that would be much appreciated. We'll start quite sharply. And Rachel, if you can stop the recording at the moment and then bring it back up in the presentations, that would be much appreciated. So thank you very much, and we'll see you in 10 minutes.